People versus Trader Guyton.
Nimish Ganatra for the people.
Ready again, Judge. Torshel Feaster, Assistant Public Defender, on behalf of Ms. Guyton. Ms. Guyton, please state your name for the record.
Treated Guyton.
Thank you, Judge. If you recall, we were here a couple of weeks ago, at which time Ms. Guyton was supposed to turn herself into the county jail. My understanding is she did not turn herself in on the day and time the court ordered her to, but that she did later turn herself in. We're asking for an adjournment now that she's in jail. Go ahead, Judge. I'm sorry.
It kind of happened like that.
Okay. Yeah, I think there was some.
She was supposed to turn herself in on April 14th. She didn't. She then attempted to file an online bench warrant request because she knew she didn't turn herself in. That was on April 19th. We denied that. And the 19th was what day? That was a Wednesday. And then she decided, well, might as well try to deal with it. And then finally turned herself in on the 22nd, but then left.
They let me go.
Oh, yeah, okay. I don't know if they let you go.
Yes, sir.
But then somehow or another, then she came back.
Can I please speak?
Hold on, Ms. Guyton. Judge will let you talk. Let Judge know what we want to do today.
Oh no, I'm done with her journey.
Buckle up, guys. Today we're going to break down a courtroom moment where everything goes sideways right out of the gate. The case is called Formalities Barely Finish, and the judge is already focused on one critical issue. The defendant didn't follow a direct order to turn herself in. As the defense starts explaining, the timeline gets messy fast. Dates blur, responsibility shifts, and the judge pauses the conversation to regain control, setting the tone for a tense and accountability-driven hearing.
Okay, Judge. I also submitted in this file a late referral to drug court in this matter. Ms. Guyton and I had spoken, and I think she's an appropriate candidate for drug court. I had spoken to Mr. Ganatra about this previously, and I believe he does not have an objection. So I'd like to have her referred, and then I think Ms. Guyton wants me to do a couple other things also.
All right. Then drug court referral, they don't have the prosecutor's signature. I'm assuming, Mr. Ganatra, you don't have an issue with that.
No, you can please sign with my permission.
Okay. Seems to be a consistent theme with Feaster.
I'm working on getting better.
No, I'm just saying, man. I'm just saying. All right. Okay, and we'll put this out 3 weeks to you want the 16th or the 23rd?
16th.
Or 16th.
We'll keep them consistent.
Probable cause conference will be adjourned May 16th. What else did anybody want to address with me?
Thank you, Judge. I believe Ms. Guyton wanted me to let the court know that she has secured a bed at a rehabilitation center. And I believe that was part of her hesitation, she tells me, in turning herself in. She was hoping to go to an inpatient facility. Where is that at, Ms. Guyton?
Spear, Dawn Farms, Spear. I might be saying it wrong. Spear, at Dawn Farm.
All right. And so I think she is asking around if you would consider releasing her to inpatient treatment to Dawn Farms, provided that the bed she had previously secured is still available.
From here, the court digs into the timeline, and the problems only stack up. The prosecutor calmly lays out how the defendant missed her surrender date, attempted an online bench warrant recalled days later, and only acted after that failed. The defense pivots, requesting a referral to drug court, trying to redirect the focus toward rehabilitation. While the prosecutor doesn't object, the judge's reaction suggests this case already fits a familiar pattern he's seen before.
Can I speak or wait?
Go ahead.
Oh, okay. Yeah, I've done my intake. I've done my access, my access to my everything to access. I've done my intake. I've done everything I needed to do. I was ready to go, bag packed and everything. I was supposed to be there Monday at 1:30. But like I said, I didn't know what to do between Judge Simpson and then that. So all I gotta do is once I get down home, call them, and I'm back in. I got a bed. But my bags are still packed. I've done everything I need to do, just gotta go.
Miss Guyton,
Yes,
you knew I ordered you to jail. Why didn't you go there on the 14th?
I didn't hear, I swear, I didn't hear that part that was the part when you said what time and what day to turn myself in. Only way I finally found out was through my probation officer. I turned myself in twice. The second time they kept me, the first time I came.
Well, hold it. So when you found out from your probation officer, then you knew I told you to go to jail. Why'd you file an online bench warrant recall?
I don't know, just see if it worked.
Okay, well, that's an honest answer. Then you came to the jail on April 22nd.
And then I told them I had a bench warrant the whole 9 yards. I got there at 7:45 in the morning. I stayed to 10:30. And then they came and told me, you can leave if you want to. You stay or you can leave. That's all they told me. So
They told you you could stay or leave because there was a bench warrant out.
Yes, exactly.
Okay. And so if that was the case, then did you go back?
Yeah, I let me come and came back again.
When did you go back?
I went back the next day.
Why'd you go back the next day if they told you you could leave?
Because something didn't sound right. For them to tell me I can stay or leave.
Okay, so something between the time you left and the time you came back, something just didn't sound right.
No, it didn't seem right. I'm trying to,
Yeah, so you went back.
This is where the courtroom pressure peaks. The judge directly questions the defendant about why she ignored a clear jail order. Her answers come out hesitant and inconsistent, admitting confusion but offering little clarity. When the judge asks why she filed paperwork instead of reporting to jail, even she seems unsure. Each follow-up question exposes more gaps in the story, and the judge's calm but relentless tone highlights growing concerns about credibility and personal responsibility.
Yeah.
Yeah, that might have been because they told you not to leave.
No, they didn't tell me to leave, Your Honor.
Oh, okay. All right.
They didn't tell me. They told me I could stay or leave. They really did. So I left.
Yeah. Sheriff's Department always does that. In the face of a bench warrant, they just tell you to leave. All right. Mr. Feaster, anything else you want to add to what your client has indicated?
Not at all.
Bond will continue as it's currently set. I want to see if she gets into drug court before I want to see what the assessment says before I release the inpatient treatment, because I'm not sure whether or not she may have a bag pack, but I'm not sure that there's anything waiting there for her, given the behavior of the defendant.
Thank you very much, Judge.
Thank you.
So you're gonna
Sit tight, Miss Guy, and I'll come see you.
You might tell her that she can leave. I'm just kidding. Kirkho's case. People.
In the end, the judge pulls everything together and makes his position clear. Bond remains in place, and any release to inpatient treatment is put on hold until drug court evaluations are complete. He openly questions whether there's anything truly waiting for the defendant on the outside, given her behavior so far. The ruling closes without drama, but the message is firm and unmistakable.